HR Legal Lowdown, where we decode parts of employment law in short videos. I am joined today by Phoebe Strach, partner here at HR Legal, and today we're discussing when it's unlawful to discriminate based on someone's criminal record. So before we get started, Phoebe, are employees required to disclose criminal records?
In short, no, Alex. Generally, employees are not required to disclose criminal records. Having said that, if an employer asks about a criminal record and the employee has criminal convictions, they should be disclosed, and it can be problematic for the employee if they don't.
Right.
At the same time, if there are job-specific exemptions, like working with children checks, or for certain jobs like in health or in security, disclosure may also be required by law.
Sure. So can employers undertake background checks on employees?
Yeah, absolutely. Employers can conduct background checks, but there are a couple of things that they should be aware of, and I suppose best practice steps that should be taken into consideration. This includes written consent from the employee around conducting the background check, making sure that the checks are relevant to the role that the employee is to perform, and the information is used to assess the suitability for that role. You should also take into account the application of anti-discrimination legislation and also privacy laws where applicable.
Sure, so that's a great coverage of the basics. Can you just tell me about discrimination? Can you discriminate against someone with a criminal record?
Well, it totally depends, Alex. While employers sometimes do have concerns about an employee's potential criminal history, under some state and federal laws, it's unlawful to discriminate against someone on the basis of an irrelevant criminal record or a spent conviction. So employers have to tread carefully when it comes to making decisions about hiring or retention in this space.
Sure. So you mentioned spent convictions. What actually is a spent conviction?
Yeah. So in many jurisdictions, a criminal record becomes spent after a certain period of time, and that's typically 10 years for adults, and employers are prohibited in taking these into account in employment decisions.
Right.
But even if a conviction isn't technically spent, the key question is it relevant to the role? If not, treating it as a disqualifier can be discriminatory.
Right. So what practical advice would you give employers on conducting police checks?
Yeah, great question, Alex. Firstly, it's around understanding what's legally required in your jurisdiction. Secondly, it's about assessing criminal records on a case-by-case basis, because not every conviction is going to be relevant to every role.
Sure.
Employers need to have a process that fairly assesses whether a person's criminal history affects their ability to do their job. Finally, if in doubt, seek legal advice, because assumptions can lead to significant legal risk and reputational risk as well.
So we definitely recommend that you contact HR Legal if you need further advice in this space. Thanks for that summary, Phoebe. A strong reminder that discrimination law extends well beyond the usual attributes, and a criminal record, if irrelevant, should not be used to exclude someone from work. Thank you so much for your time today, Phoebe. It's been a pleasure to interview you, and as we said before, if you need any help in this space, please contact our team today. My name is Alex. I am the Business Development Manager here at HR Legal, and thank you for your time today.
Thanks, Alex.
My name is